Good morning, everyone. Welcome to the 200th District Court. This is Judge Jessica Mangrum. We are here in Toledo versus Herring. If we could start off with appearances of counsel, please.
Kenneth Tragover for Plaintiff Maria Polito, Your Honor.
Judge, I'm Ross Pringle. I'm going to be handling the hearing today for Defendant Herring. I'm also trial counsels with me, Heidi Coffin and Callie Haley.
Okay. Good morning, everyone. Mr. Gober, it's your motion, so you may proceed.
Good morning, Your Honor. Kind of just want to start with a brief recitation of the relevant facts. We're obviously here on a motion for new trial after a week-long trial. We tried, obviously fairly recently in your court, and I'm sure the court remembers the trial and a lot of the facts. At a 30,000-foot level, this is a case where it's a rear-end collision for the defendant to have rear-ended our client, the plaintiff vehicle. What's going to be important in our conversation today is distinguishing case law that's cited by the defense and by the plaintiffs. And it's without dispute that a mere rear-end collision is not enough to say King's X 100% liability on the defendant. And we have to establish that there's additional facts on top of the fact that it's not a quote-unquote mere rear-end collision. We think that we've established that, and I'll point out some facts. Obviously, everything has to be taken in the light most favorable to support the verdict of the jury. One fact that will distinguish this crash from some of the case law cited by defense counsel is this occurred on a roadway. It's while the defendant was approaching a red light and saw that the plaintiff was stopped. The defendant at the time of the crash was changing lanes, or he was in the process of merging over where the lanes opened up. The plaintiff vehicle was seen by the defendant with its brake lights on prior to the crash. The defendant admitted that he took his eyes off of the road prior to the crash in order to grab a Red Bull that had spilled. And the defendant admitted or accepted 100% fault. Obviously, there's case law that distinguishes accepting fault versus negligence liability, but it is a factor that can be considered by the court in determining what was against the greater weight of the evidence for the jury. Further, the speed of the defendant vehicle was contested at trial to some extent, but there was also a lot of agreement. And in the light, I think the light most favorable to the defendant is to look at what the defendant's expert said as to speed, which is much faster. I mean, in the order of like 200% faster than what the defendant testified his speed was at the time of the crash. The math simply just didn't support the defendant's estimate of his speed. And so if we look at the fact that the defendant saw the plaintiff vehicle ahead of him and saw the brake lights, that specific issue is analyzed by the 14th Court of Appeals, Jordan v. Walker, 448 Southwest 2nd, 837. And again, it's those facts that are more than a mere rear-end collision. And in that case, the appellate court upheld the trial court's directed verdict against submitting liability to the jury. The other fact that was important that we cited, Your Honor, the fact that the defendant saw the plaintiff vehicle stopped ahead of him. That's analyzed again by the 14th District in Priest v. Myers, 598 Southwest 2nd, 359. And basically, as the court at that point says, if the defendant sees brake lights, sees the car in front of them stop, then we know that the only reasonable inference that can be drawn is that the defendant failed to maintain a sure, clear distance. And then the admission by defendant that he took his eyes off of the road, that's an additional fact above and beyond near rear-end collision. That's discussed in the Lechner opinion. Lechner, I'm probably pronouncing it wrong. That's also cited in our motion. Lechner v. Kelly, 467 Southwest 2nd, 652. In that case, the defendant took his eyes off of the road, looked down to grab some business papers that I think had fallen. He was picking them up. There was obviously during the trial, I think it's appropriate to do a mini harm analysis to the result of the verdict. I apologize, Your Honor. There was a dispute, obviously, as to the extent of the plaintiff's injuries that were caused by the crash, but all medical testimony from both the plaintiffs and the defendants, qualified experts that could testify as to medical causation, agreed that Mrs. Polito, the plaintiff in our case, would have suffered at least some injury, something more than some de minimis injury as a result of this crash. So my short take on how it happened: jury gets the case. It's the end of a Friday. Defense counsel makes an argument, answer no to the liability question. You go home today. You don't have to come back Monday. The causation issue was hotly disputed in trial. There were experts on both sides. It was going to take a while for the jury to wade through causation. And so I think that the jury, coupled with argument of defense counsel, say no on liability, Mrs. Polito walks out of here not owing any money. This was based on some argument on what Dr. Sani, plaintiff's surgeon, had testified to. The reality is that as a result of this case, Ms. Polito still owes $345,000, give or take, as a result of her treatment that she received. And finally, I'll finish with it because I think it's important. I know that the court, and I think the court properly should, consider judicial efficiency. Trials are not cheap for the litigants. They're not inexpensive for the taxpayers, which I think is probably the court's concern generally and appropriately. But there's a cost to allowing this verdict by this jury to stand, in that it will encourage additional litigation from insurance companies, where even when we have a solid rear-end collision with these aggravating factors, instead of accepting liability as the insurance company did on this case, where the dispute was merely causation, we're going to see more cases going to trial in Travis County. If we can have cases with these kind of facts, the juries can say no as to liability. That's all I have right now, Your Honor.
All right, Mr. Pringle.
Thank you, Your Honor. Again, my name is Ross Pringle. I represent the defendant in the lawsuit. I've been asked to respond to the motion for new trial by Ms. Coughlin and Ms. Haley. My argument will track my response, which I trust the court has, and even though it's lengthy, may have even had an opportunity to review it. I want to address a couple of things that Mr. Gober mentioned that I think really don't have any place in the motion for new trial hearing, and that is the notion that the court ought to consider granting a motion for new trial to forestall additional litigation. This case ought to rise and fall on its own facts, on its own evidence, on this trial that went forward for the week in front of Your Honor, and was decided by this jury. And the notion that the court ought to grant a new trial so that rear-ender cases get settled in the future, I think is inappropriate. I would also say that some of Mr. Gober's arguments concerning the harm analysis are highly speculative in terms of the available information that we have to review those right now. I noticed that it wasn't contained in the motion. So, and obviously I wasn't at the trial. I suspect Ms. Coughlin and Ms. Haley could probably speak to that better than I could. But again, I don't believe that the harm analysis is before the court at this point. So let me just kind of start with my presentation here and address the issues as I see them. This was a very minor accident at a stoplight. the available trial evidence, and when I say the available trial evidence, what we have so far is opposing counsel had requested the transcript of our client's testimony, Dr. Rawson Wood, I believe, and Dr. Sani. So that's really all we've seen so far in terms of the transcript. Again, I wasn't at the hearing, so I wasn't at the trial, so I don't even have a recollection of what the trial evidence was. Ms. Coughlin and Ms. Haley May, and they certainly will better than I do. But that's what we have to go on right now.
Mr. Pringle, let me interrupt you. Mr. Gober, we're seeing a different screen without you on it. It's a little.
I'm gonna
Direct.
flip that around. It's the camera is trying to find who's talking, but I'll fix it right now, Your Honor.
Understood. Okay. Go ahead, Mr. Pringle.
I'm sorry, I hadn't noticed that. So the available trial evidence I've summarized in paragraph 3.2 of our response, which is on page 5 and 6. Essentially, the plaintiff was stopped at an intersection. Our client, Mr. Herring, was slowing as he approached the intersection. The light turned green and the plaintiff began to move away from the light. Mr. Herring had spilled a drink in the floorboard, but he deferred reaching down to pick it up until he determined it was an appropriate, safe time to do so. When the light turned green, she began to move away from the light. That's when he began that's when he bent down to pick up the drink that was in the floorboard. And his attention was diverted very momentarily, perhaps a second to a second and a half. In this interim, the plaintiff hit her brakes unexpectedly. The vehicles were very close, and he bumped into her at a very slow speed, something on the order of 2 to 5 miles an hour, something like that. And importantly, Judge, he asserted that he was acting with ordinary care at the time of the accident. As we know, the accident wasn't reported to the fire or police. No EMS vehicle attended the plaintiff on scene, and she first sought medical treatment after consulting with her lawyer. So the case goes to trial. The court submits a very simple charge of 2 questions, a negligence question and a damage question, the second conditioned on the first. And the jury found that no negligence of Mr. Herring was a proximate cause of the accident. So you'll note from my response, Judge, that I go into an analysis and a discussion of the standards in granting a motion for a new trial now in this now really since 2009 when the court decided in re Columbia Medical Center. As we know, the jury is the sole judge of the credibility of and the weight of the testimony, and the amount of evidence, Judge, necessary to support a verdict is a low threshold. And jury verdicts are to be given great weight and deference. In this Columbia Medical Center case in 2009, that's when the court modified and overturned and totally revamped this notion of granting a motion for a new trial. Before that, trial courts were authorized to grant motions for a new trial, quote, in the interest of justice, with no explanation, with no justification. Essentially substituting the trial court's judgment for that of the jury after a hard-fought contest. After in re Columbia Medical Center, in those very rare occasions in which a jury verdict is disregarded, as Mr. Gober is asking the court to do in this case, the trial court must explain with very factual, specific, evidence-based specificity why it elects to substitute its judgment for that of the jury. And that case instructs that the court should detail all the relevant evidence and explain how the evidence outweighs the evidence supporting the verdict, or how the evidence is against the great weight and preponderance of the evidence as to be unjust. So that's a burden and a procedure that the court must engage in if it even considers overturning this jury verdict. Now, the plaintiff's response, and we've heard it again today, stipulates and agrees that the occurrence of a rear-end collision is no evidence of negligence. We've cited the court to cases in our response that in rear-end collisions, ordinary care is not fixed with certainty, but must be left in large part to the fact finder under the facts and circumstances of each particular case. And again, these cases are contained on page 3 and 4 of the response to the motion. So the plaintiff's response correctly states the standard for overturning a jury verdict on a no evidence challenge. The court has to review the record and consider only evidence that supports the jury's no answer to question one, if a reasonable fact finder could consider that evidence, and disregard contrary evidence against the jury findings unless the reasonable fact finder could not disregard that evidence. And only if no evidence supports the jury's no answer to question one will the court review the entire record to determine if the evidence conclusively establishes that Mr. Herring was negligent and that his negligence was the proximate cause of the accident. So even though the plaintiff cites the standard, they don't apply it in their motion. And so we have applied it in our response, and that's contained on page 5 and 6 of our response. So again, from this limited partial record, just 3 witnesses of a 3-week trial, this is what we've been able to glean is the available evidence in support of the jury's verdict, which we contend is clearly legally sufficient evidence, far more than a scintilla, that Mr. Herring was using ordinary care. He was braking on his approach to this intersection. He was checking his mirrors. Even though he spilled his drink, he was maintaining his attention on the traffic ahead of him, even after spilling his drink. He came to a stop or close to a stop behind the plaintiff when she was stopped. And at that point is when he reached down and attempted to pick up the spilled drink, only when he thought it was safe to do so. Again, diverting his attention extremely momentarily for a second or so. At that point, the plaintiff applied her brakes. They were very close together. He jammed on his brakes, but he was unable to avoid colliding with her and tapped her bumper. So I've cited the court to a case called Nice versus Dietz, which is described in detail on page 7. Again, the plaintiff stopped at a yield sign in Nice versus Dietz, appeared to proceed. When she appeared to proceed away from the yield sign, the defendant behind her checked for oncoming cross traffic. His attention was momentarily diverted, much like Mr. Herring's. And in that interim, the plaintiff stopped suddenly and he bumped her from behind. And in that case, the court deemed that the evidence was legally sufficient to support that no evidence finding. I've also cited the court to Stone versus Sulak, which is an Austin case, which is a wreck which occurred at the intersection of 183 and I-35. Again, similar facts. The plaintiff stopped at an intersection and began to move away. The defendant was behind her. He began to move away as the plaintiff began to move away, and he diverted his attention momentarily from her vehicle to check for oncoming traffic. She stopped short, got bumped, and the jury found that neither party's negligence was a proximate cause of that accident or any of the injuries. And again, that was upheld by the Austin Court of Appeals. Judge, we've cited the court to multiple cases in the brief, in the response, to support the jury verdict here that's listed on page 8 and 9 of our response. Again, it's just authority that the trial court should not and cannot substitute its judgment for the jury after this fair contest. The 3 cases cited by the plaintiff are inapplicable, and most importantly, they predate this limitations on new trials imposed by the Supreme Court in 2009 with the Columbia Medical Center case. In the Jordan versus Walker case, this is a 1970 case that Mr. Gober cites. In that case, again, the plaintiff began to move and stopped suddenly when the defendant's attention was momentarily diverted. But in that case, there was absolutely no evidence that the defendant was acting with ordinary care and no evidence to justify or explain the collision inconsistent with the finding of negligence. Again, totally distinct from our case, we have ample evidence to support our client's no answer. In Lechner versus Kelly, also cited by the plaintiff, the defendant saw the car in front of him and was attempting to stop looked down at papers in his car and just rolled into her. There was no evidence of the plaintiff starting and stopping as we have in this case. And again, the defendant made no reference or no contention of extenuating circumstances, such as this partial record establishes with Mr. Herring. And finally, the Priest versus Myers case, which is cited by the plaintiff. The fact that what I would mention about the Priest versus Myers case first is that case was submitted on granular issues, which is a now disfavored practice in trial courts. The court submitted separate questions for lookout, assured clear distance, and speed. And the court held that because a rear-end collision occurred, the failure to maintain assured clear distance between the vehicles was negligence as a matter of law. Now that flies in the face of the maxim that we all agree applies, that the evidence of a rear-end collision is no evidence of negligence as a matter of law. And when you think about it, Judge, this notion of the failure to maintain an assured clear distance just means that the distance between the cars wasn't far enough to prevent them from colliding, which means that there was a rear end accident. So it's kind of a jump start and kind of a bootstrap into this notion that they were hit from behind, therefore there must be negligence as a matter of law, which we know and all agree is not the law. So Priest versus Myers is a 1980 case, again submitted on these disfavored granular issues, not on a broad form submission as we submit cases now. Now, I have cited the court to a case called Pearson versus DeBoer, B-O-E-R, which is a 2003 case holding that alleged failure to maintain an assured clear distance is not negligence as a matter of law. That case is detailed at pages 11 and 12 of the brief. I won't bore the court with just reciting what's in my brief. It's there for the court to review at your leisure. So clearly, Judge, there's ample evidence, certainly more than a scintilla, to support the jury finding that Mr. Herring was not negligent. It's set out in our brief. The court will recall it. And more importantly, Judge, the jury heard all this stuff. They heard all this evidence. They weighed the evidence, and they performed their function as the arbiters of the credibility of the evidence and the weight to be given their testimony. And they determined after this hard-fought battle that Mr. Herring was not negligent. And the plaintiffs come nowhere close to carrying the heavy, heavy burden to ask this court to substitute its judgment for that of the jury and overturn this jury verdict. Now, I want to move to the factual sufficiency point in the motion for new trial. And I've addressed that on page 12 of my response. Essentially, Judge, there are two issues that they raise. One I call a speed discrepancy. The argument is made that that Mr. Herring testified he was traveling 2, 3, 4 miles an hour, something like that, based on his recollection of how the accident occurred, versus Dr. Rawson Wood's scientific analytical testimony that he calculated that Mr. Herring was traveling between 5.6 and 7.1 miles an hour. The plaintiff contends that this is, and we heard it, a 200% difference between what the defendant said and what his expert said. First thing I would mention, Judge, is I think that the plaintiff inadvertently mischaracterizes or omits some of Mr. Herring's testimony, because what Mr. Herring testified was he testified his speed was somewhere between 2 and 6 miles an hour, an estimate of which he was not 100% sure. And again, I've addressed the case site or the citations to the limited available transcript where he testified to that. So we have Mr. Herring testifying it's between 2 and 6 miles an hour, and Dr. Rawson Wood calculating it's between 5.6 and 7.1 hours. So one that's not inconsistent, it's highly consistent, and in fact, it probably enhances Mr. Herring's credibility, the jury, that his testimonial recollection of what happened years prior is consistent with the scientific analysis of a qualified expert. His estimate is clearly within the range of the expert's calculation. And again, not to beat a dead horse, but the jury is the sole arbiter of the credibility of these witnesses. They heard all this, they weighed it, and they made a determination. The second issue that's raised in the factual analysis portion of the plaintiff's response is the notion that Mr. Herring accepted responsibility for this accident. I've cited the court to 3 separate cases in that regard. Reisinger versus Shoemaker, Roberts versus Staple, and Pearson versus DeBoer again. And there's also an internal citation to a Fort Worth case called Campbell versus Perez. Again, these are all in the brief. I won't bore you with going over the brief or the response any more than I need to. But all of those cases held that these are, the acceptance of responsibility are quasi-admissions. It's a factor. It's some evidence. It is not conclusive. It is not compelling. It is not dispositive. Again, the jury heard that and they made their determination. I would also point out that acceptance of responsibility for an accident is greatly distinct from a stipulation of negligence. Mr. Herring never said, I failed to act with ordinary care. He said, it's my fault. I hit her from behind. My car hit her car. It's my fault. But that is not equivalent to a stipulation of negligence or any sort of compelling evidence justifying or that might justify this court taking away this jury verdict. So in summation, Judge, the 4 of y'all were there. I was not, but this was a hard-fought trial on both sides. The jury heard the evidence, heard the lawyer's summation and characterization of the evidence. The jury performed its duty and determined the credibility of the witnesses and the evidence and the weight to be given their testimony. And after weighing all that, they performed their duty and found that Mr. Herring was not negligent or that his negligence was not a proximate cause of the accident. This is supported by the legion of cases that are cited in our response. The plaintiff is asking the court to substitute its judgment, or perhaps even the plaintiff's judgment, for that of the jury. But a detailed and evidentiary analysis of the trial evidence compels denial of the motion for new trial, Judge. Thank you.
Okay, Mr. Gober, your motion, so you have the final say.
Yes, Your Honor, and I'll be very brief. I want to touch on the harm analysis. There was a discussion of whether that evidence was properly before the court at this time. That's contained within Dr. Rawson Wood's testimony, the transcript that's been submitted as an exhibit to our motion. Dr. Wood was the medical causation analysis or expert for the defense, and he confirmed that Ms. Polito would have suffered some injury. I don't want to misquote him, but paraphrasing, I believe it was sprain, strain, and would resolve on its own after a few weeks. Obviously, we disagreed and contended that the injuries were much more serious. The point being, though, that even the evidence most favorable to the defense concludes that there was some medical injury caused as a result of this crash. I don't want to belabor the speed. Obviously, that was a contested issue. I believe Dr. Wood actually testified. It's on page 30, line 21 of the transcript, that the defendant vehicle was going between 7.9 and 10.1 miles per hour. The 5 mile an hour number that the court has been provided is the delta V, the difference in speed of the vehicles at the point of collision. Again, I'm not really trying to argue or belabor that particular fact issue. The point is that the evidence most favorable to the defendant's expert concludes that the defendant was going faster than an idle speed. That was further discussed as well in the transcript of Dr. Wood. Finding or granting this motion for new trial is certainly well within the court's discretion. And negligence isn't about all of the things you did right as a driver. Negligence is about the act or omission that proximately caused the injuries that caused the occurrence in question. And so, no one gets to defend themselves in a murder case to say, I didn't murder that person, I didn't murder that person, I didn't murder that person. It's about the bad thing that they did that one time. It's about taking eyes off of the road. And so in distinguishing our cases that we've cited, these specific additional facts that support more than a mere rear-end collision, even though the Jordan, Priest, and Lechner cases predate Columbia, the reality is that each of those cases are based on something that's more than a mere rear collision. And that's why we cite them. And that's why we support our position given a Columbia analysis. Jordan, the defendant, saw brake lights and proceeded anyway to the rear end collision. That's the same as our case. In Priest, the defendant saw that the plaintiff was stopped ahead. That's the same as our case. That's the additional factor on the rear end collision. And on Lechner, the defendant took their eyes off of the road, besides it just being a rear end collision, and admitted that, just as in our case. With that, we stand on our motion, the case is cited, arguments made, and ask the court to grant a new trial.
All right, counsel, I appreciate your preparation for the hearing today. And I have reviewed the motion and the response. I am going to take this under advisement. I do want to pull a couple of the cases that have been cited on either side that I'm not as familiar with. So I'll take the time to satisfy myself in doing that before reaching a decision. I think it's likely that you will get a decision by the end of next week, though. All right. So any questions before I excuse everyone from the virtual courtroom?
Judge,
No,
would you like the parties to submit proposed orders? Or do you want to wait for the
We'll
ruling?
already have.
Oh,
I
okay.
think we all have them.
Yes, we got an order from each side this morning. So I don't think we need anything else from either of you on that. So I appreciate your preparation, and we'll give everything that you put in front of me due consideration. And just as soon as a decision is made, you will know about it and either get an order